Can you leave him out for 2 seconds while I ask probation a question? Thank you. I'm just gonna ask one question real quick, and I'll be right back. Hey, are they picking up at Wilbur? Is Wilbur picking up? They are? Okay. Okay, thank you.
Can you pull David Brewer to the window? He in one. Brewer.
Okay, thank you. Wilbur.
I'll be right back. There it is. Thank you, sir.
A year ago, you been in here?
Good morning.
Morning.
Oh, yeah, there was one. Yeah, that is down. Huh?
My God. Yeah, do me that favor because
All right, Bram, you all are muted. All right, good morning. Hold on. Oh, you know what? My volume is off. That's why I can't hear anybody. Give me 1 second. Okay, there we go. All right, Bram, color. And if somebody is watching on Face, or actually, we're on YouTube. Do you hear that, Lisa?
I heard an echo at first. I don't hear it now, but I did.
Yeah, I hear an echo.
I don't hear it anymore.
Well, no, that was the echo still going.
Oh,
Yeah, I don't know what that is. Okay. I don't hear it now that Brain is muted for some reason. Yeah, I muted them. Oh, no, no, Lisa. Oh, that's still the echo going.
yeah. Where would it come from? Because everything's muted.
Okay, I'm gonna say something now and see if it starts echoing. Lisa, raise your hand if you can hear me. Okay. Now we're gonna see if it echoes in like 2 seconds. I'm not sure why it's echoing. Okay, well, we're gonna try to move forward even though this echo situation is happening. Maybe I can figure it out. All right. Brian, y'all are muted. Can you all call the hall on the first page for Blanchard?
Okay.
And Cooper Garrett
Cooper Gary.
and Delgadillo.
Said
Delgadillo
Okay.
and Dixon.
Okay.
Yeah, it's repeating what I'm saying, so you're hearing it twice.
No, I only hear it once.
Really? Oh, so I'm just hearing myself echo. Lisa, are you hearing it echo? Gosh, okay. So Cooper, Garrett, Delgadillo, Dixon,
Blanchard.
and that's it for the first page.
Okay.
Okay. I'm the only one that's hearing it. It's horrible. It's literally repeating everything that I say. So Lisa, I'm going to try to stay focused, even though I can hear myself twice.
You can just say everything twice for the record.
Oh, man. Let's see. Okay, yeah, so we're on Instagram Live today too, because we can't stream on Facebook right now, but we're on the court. So if you all are on Instagram Live and you all want to watch the court like you would normally watch the court, just go to 282 Court's YouTube page, okay? And it's streaming publicly. We also posted the signs and they're listed outside the court so that you all can know how.
Okay.
Thank you.
Okay. So let's see if that helps.
Does he need to stay?
But what I was saying was the Texas Office of Court Administration has purchased the Zoom accounts for us, and it allows us to stream on either YouTube or Facebook. Facebook obviously is where, you know, more people are able to watch. So that's my preference, but we're on YouTube today. So if you want to go to our YouTube, it's just 282 Court. Okay.
So Judge,
And I know y'all on Instagram Live can hear me twice. I'm so sorry. Let me try one more thing.
Does anyone have the quarantine list?
Give us 1 second, Ms. Burris. If they're quarantined, we'll let you know as it goes, okay?
Okay, thank you.
Oh, even y'all are echoing for me. Lisa, I'm gonna log out and come back and see. It's gonna make you host, okay?
Okay.
And see what's going on with this, why everybody's echoing for me. Let me-
did you sign in? Oh, it's closed up. I think so. Not supposed to do that. Did he respond to? What is that? Say that again. Tell her she already called tonight. She waiting on it.
Okay. Reclaim host. And Lisa, say something. Let me see if it echoes again.
Can you hear me?
Okay, I heard you the first time. Please don't let me hear you a second time. Now, Lisa, on your computer though,
Uh-huh.
the let me just check. Can you go on your phone and do 282 Court YouTube, or actually just search YouTube, and in the search box do 282 Court. Let's make sure it says we're still streaming on YouTube, but I want to make sure that we are.
Yep, I see us.
Yes, look at this. Problem solved. We're problem solved. Okay. All right. No more echoes for us over on this end on IG Live. We can hear everything twice and everybody. All right. On to the business. Now, Brian,
Yeah.
were you all able to, when you called the hall, did any of those people answer?
Charles Blanchard answered, and he's in the courtroom, and Shatara Dixon.
Okay. Is Blanchard's attorney with him?
Mr. Blanchard, he said that he's on Zoom.
And he is Neil Pask, and he is not on Zoom. So tell Mr. Blanchard to have a seat in the hallway and call his attorney, tell him he missed the first call.
Okay. And then
So Mr. Blanchard, head out to the hallway.
And Ms. Dixon's attorney said he's on his way to the courtroom.
Good morning.
Good morning, Ms. Van Bolden.
How are y'all doing?
Doing well. How are you?
Doing great on this Thursday. Thank you.
Yes. Thank you for coming on with such a good spirit and speaking to everybody. All right.
My pleasure.
Okay, let's see. Sheriff, I saw Mr. Johnson in the courtroom. Is he still in the holdover with his client?
Yes, he is.
Okay, tell him I'm ready. He needs to come out. And then Ms. Burns, who has the paperwork for? Ms. Burns.
Good morning, Judge.
Good morning.
Morning. I apologize. Something was wrong. It wouldn't let me activate anything. Whose client is this? I'm sorry. Who's the defendant?
Brewer.
Brewer. Okay.
Yes. Who has the plea paperwork for him?
Judge, if I may,
Uh-huh.
he has a third case that just came back from the grand jury yesterday. It was just true build. And so we're going to try to see if we can reset him for either whenever you're available, either tomorrow or Monday, just so we can plead all at the same time.
Okay. So State, did you all already know that you had to have known that there was a third case? You all didn't talk about maybe a grand jury waiver, or they didn't want to do a grand jury waiver?
I am not sure yet, Your Honor. No, I don't think that we were aware there was a third case. Let me go in and see if they're linked, because sometimes that's a problem. Yeah, Judge, apparently they weren't linked. They're still not linked right now that there's a third case
Okay.
for that one. So we didn't know about it. I
All right,
will.
RC, is the docket packed tomorrow? Okay, thank you. All right, Mr. Johnson, give me 1 second. We're gonna see if Monday or Friday is best since you all
Thank
were set today. Let's see. Here, do we have Carol up? Cody Carroll?
Oh, sorry.
Mr. Johnson, did they say anything?
Excuse me, Judge?
Oh, I'm trying to ask Bram a question. Bram, is Carol up?
Carol, yes, Judge.
Okay, I'm ready for him. Mr. Johnson, if you can step to the side for me.
Yes, Judge.
And Ms. Burris, who has the Cody Carroll paperwork?
I should be that you have it. Let me go in and check.
Well, you all will need to resend it. If somebody was reset, I don't have time with everything. I manage with Zoom and everything else, so you all can easily resend it.
Okay, I will send it to you right now, Your Honor.
Mm-hmm. What'd you say, RC? Well, just unmute because I can't hear you through the door.
Either date is fine.
Okay, thank you.
You're welcome.
So, Mr. Johnson, we can set you for tomorrow. Just turn in a pass slip with all 3 dates.
All right, I'll let them know, Joe. You just step back in, Mr. Johnson.
Yes, Judge?
Mr. Johnson, you can set it for tomorrow. Just make sure you put all 3 dates on the pass. All 3 cause numbers on the pass slip, okay?
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
And Bram, we have Coggins up, right?
Yes.
All right. And Carol, is it a probation plea or jail?
It's a plea, probation plea, Your Honor.
And what's the TRAS and any Rex? And Ms. McCabe and Mr. Atkins, if you all can activate for me.
Yes, Judge.
Okay. So while I'm operating everything else, if you all can tell me what the TRAS is and any Rex on Carol.
Of course, Judge. TRAS score was a 17 moderate. And ATRS recommendations were for IOP. And it looks like mental health treatment.
And Mr. Mays, they're pulling your client, correct?
Yes, ma'am. He's right here.
All right. And State, if you want to go ahead and send that paperwork.
It should be in your teams now, Your Honor.
All right.
Sit back and scoot up.
Hmm. All right, Lisa, let's go on the record. This is cause number F21-32881, State of Texas versus Cody Carroll. Sir, is that your true and correct name?
Yes, Your Honor.
And can you read and understand the English language?
Yes, Your Honor.
And appearances from counsel?
Stanley Mays for the defense.
Rachel Burris for the state.
And pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference today is streaming on the court's YouTube account. We're also streaming on my Judge Amber Givens live. All right. And are both sides ready to proceed?
Defense ready.
Yes, Your Honor.
Sir, you are charged by indictment with the third-degree felony offense of theft. You're looking at 2 to 10 years in the penitentiary and up to an optional $10,000 fine. You understand that range of punishment?
Yes, Your Honor.
Did you read? Did your lawyer explain to you? And did you understand every document you signed in this case, including the court's written admonishments regarding your constitutional and statutory rights?
Yes, Your Honor.
And are you satisfied that your attorneys fully investigated the case?
Yes, Your Honor.
Have you read and reviewed the indictment with your lawyer?
Yes, Your Honor.
And counsel, is your client competent to proceed?
Yes, ma'am.
Sir, do you understand that you have an absolute right to a jury trial under the constitutions of the U.S. and that of the state of Texas, the right to remain silent and the right to confront and cross-examine your accusers?
Yes, Your Honor.
You understand that by entering into a plea today, you're waiving those rights?
Yes, Your Honor.
The Michael Morton Act applies in this case. I have the discovery disclosure notice signed by yourself, your attorney, as well as the state. And counsel for the state, is this a DVD case that was impacted by the data loss?
No, Your Honor.
All right. And counsel, are you satisfied that you received all discovery?
Yes, ma'am.
And do you wish to arraign your client?
No, we waive arraignment in a plea of guilty.
And sir, as best as you can, please raise your right hand. Do you judicially confess that you committed the offense exactly as alleged in the indictment in this cause?
Yes, Your Honor.
All right. You may lower your hand. You've also heard counsel enter a plea of guilty on your behalf. Is that your plea?
Yes, Your Honor.
And are you entering into that plea freely and voluntarily because you are guilty and for no other reason?
Yes, Your Honor.
I must admonish you, if you're not a U.S. citizen, there's a possibility that your plea of guilty can and will result in your deportation, exclusion from the country, and or denial of naturalization benefits. Do you understand that?
Yes, Your Honor.
And with that understanding, do you still wish to proceed with your plea?
Yes, Your Honor.
All right. And state, please provide a synopsis of your probable cause affidavit.
On December 8th of 2020, the defendant went to an enterprise rented a brand new 2020 Ford F-150. Kelly Blue Book value was $35,499. He signed a contract to return that truck on December 10th. As of January 6th of 2021, the defendant had yet to return the truck. On January 19th of the same year, officers observed him behind the wheel of the seat of the stolen vehicle, and he was arrested.
All right. And state, please proceed.
Your Honor, State Offer States Exhibit Number 1, the defendant signed a written voluntary judicial confession and stipulation of evidence. And States Exhibit Number 2, the defendant signed voluntary Michael Morton paperwork.
No objections.
States 1 and 2 are both admitted.
State rests.
Defense rest.
State closes.
Defense closed.
All right. And sir, I accept your plea of guilty. I find that there's sufficient evidence to prove your guilt beyond a reasonable doubt. Pursuant to Article 42A.301 subsection A of the code, the court does have your risk assessment. You're listed as a moderate. With that being said, I will accept the party's plea agreement. In doing so, I'll defer adjudication of your guilt and place you on community supervision for a period of 3 years. There are 2 things you need to understand about being placed on deferred. You do have the right to petition the court for an order of non-disclosure. The only reason you would not be eligible is because of the offense you pled to today and any prior criminal history you might have. Second thing, the full range of punishment that the court reviewed with you at the beginning of the plea is available to the court should you violate your terms of probation. Do you understand both of those things?
Yes, Your Honor.
All right. And then probation informed me before we went on the record that the probation department is recommending mental health treatment for you. Mr. Carroll, were you previously receiving treatment at MetroCare?
No, Your Honor.
Okay. Where were you receiving treatment?
It was in Irving.
In Irving. Do you remember the name of the
Not right off the top.
provider?
No, ma'am. No, Your Honor.
All right. So what I'm going to do, I'm going to order that you receive mental health treatment from MetroCare. If you have another provider, you can replace that MetroCare is the provider. However, I'll need proof that you are actually receiving treatment from another provider, okay?
Yes, Your Honor.
So within 1 week from your release, you need to go to MetroCare and set up services there. You will also need to check in with the court officers within 1 week to show proof that you've signed up for services at MetroCare.
Yes, Your Honor.
And you are to use one pharmacy, and you are to provide copies of your prescriptions to your probation field officer.
Yes, Your
I
Honor.
will give you 2 weeks to sign up for your IOP classes. And I'm also going to, what's the addiction that you're struggling with? Is it alcohol or drugs?
It would be alcohol.
Okay, so you are going to attend AA meetings 2 times a week. You'll need to start that the week that you're released from Lou Sterrett. Now, Mr. Carroll, those were the only recommendations from the probation department. Is there anything else that you know you need to succeed on the probation?
No, Your Honor.
Okay, there is one thing I'm sorry that I'm going to add is that you see a psychologist once a month. Okay, and I'll give you 4 weeks to locate a psychologist of your choice. I don't want to know what you all talk about. I just want to know that you're getting the extra support that you need. Okay.
Yes, Your Honor.
All right. And so once a month, you'll need to provide proof to your field officer that you're going to that psychologist once a month. If you want to do it more, that's great. Okay.
Yeah.
All right. And then, Mr. Carroll, you said nothing else. You got a supportive base at home.
Yes, Your Honor.
Okay, perfect. So the idea is not perfection, Mr. Carroll, but it is responsibility. So hold yourself accountable. If you are struggling with something, make sure you come to the court, let the court officers know, and then they'll talk to me, okay?
Yes, Your Honor.
All right, perfect. I'm going to review with you now the trial court certification of defendant's right of appeal. It reads the same at the top. It acknowledges that this is a criminal case, and there's a box checked off above the court signature that states that you waive your right to an appeal because you entered into a plea agreement. Do you understand that?
Yes, Your Honor.
All right. And then, counsel, were you appointed or retained?
I was appointed, Your Honor.
And, sir, has your financial status changed since you were appointed counsel?
No, Your Honor.
Okay. Pursuant to Article 4215 of the code, I'm going to waive your court costs. And then I'm also, it's standard probation policy that the probation fees are $60 a month. I'm going to reduce yours to $10 a month, okay?
Yes, Your Honor.
And the idea of doing that, Mr. Carroll, is just to make sure we're not trying to trip you up, okay? So I know you have a lot going on. So we're going to make sure that that's not one thing that you're struggling with, okay?
Yes, Your Honor. Thank you.
All right, you're welcome. So, Sheriff, I need you to print him once and hold him for probation, and then attorneys, you all are excused. Let's go off the record.
Yes, Judge. Thank you, Your Honor.
You're welcome.
Come this way.
Yes, sir.
Thank you, Judge.
And then, Brian, I'm ready for Coggins.
Coggins, okay.
Let's see. Swap this. Okay.
Judge, this is Alicia Patterson's case. Do you see her in the waiting
He's in the
room?
waiting room. Mhm. All right. All right, attorneys on Coggins, is this a probation plea or a jail plea?
Probation, Your Honor.
Okay, and Mr. Atkins or Ms. McCabe, what is the TRAS and what were the recs?
He screened out of ATRS, Judge, and his TRAS is low mod.
And then Ms. Patterson, did you already send me the paperwork and teams
Yes, Your Honor.
today?
Yes, Your Honor.
Okay, press enter because it hasn't come through.
Sure.
Oh, no, I see it. All right. Okay. Let's see. And defense and state, did you all include the weapons form in the packet as I scroll through?
I do not believe so, Your Honor.
Okay, you all need to do that by law. So I guess you all are not ready. So Sheriff, you can put him in the alternate screen and I'll send him to the a breakout room with his attorney. And state, I'll send you too, because you may need to share your screen for defense counsel to see a copy of it, unless you want to email it to him so he can go over it with his client.
Yes, Your Honor. All right, you all have received your invitation. And Braham, did you say that? What did you say about Cooper Garrett? That's when I logged off.
You said, what was that name?
Cooper Garrett, did he answer up?
Cooper Garrett. No.
I'm here for Ms. Garrison.
Okay. Mr. Duplantis, is your client at the courthouse?
She is not, Your Honor. She could not make it today. She asked if there's any possible way she could come in tomorrow.
No, I mean, she can, but I'm going to issue a warrant because y'all have had a lot of notice about her needing to come. So she can come tomorrow and you just have to, you'll be off docket. So I always handle the on docket matters first. So she'll just have to be patient, and same with you. Okay. All right, Braham, that'll be a call the hall.
Miss Dixon is right here.
No, I'm looking for Cooper Garrett.
Oh, okay.
I'm here for Ms. Dixon as well, Your Honor.
Okay. So now that we've handled Cooper Garrett, that's a BF. All right, Sheriff, Miss Dixon can have a seat at the table. And Mr. Duplantis, who's your prosecutor?
It's Jennifer, Your Honor.
Okay, so Miss Burris is stepping in. Okay. All right, so state, if you can tell me when the initial offer was conveyed and when discovery was made available.
Discovery was extended on February 26, 2019, and then subsequently the offer was extended on November 9th of 2021.
When was the case indicted?
Case was indicted. Sorry, Judge, I made a cheat sheet, so I don't have it pulled up. Let me do that.
Rachel, I have discovery made available on December 2nd, 2021.
I think that was more discovery. Maybe that was discovery to you, but we initially made discovery earlier. Let me pull it up. It was indicted, Your Honor, on October 26th of 2021. And it looks like the first incident. Oh, I misread. You're right, Stephen. It's 12/2 of 2021. I misread the email. I apologize.
Okay. So the case got indicted and then discovery wasn't tendered for like 2 months. Okay.
It appears that way, Your Honor. Yes.
All right.
But an offer was given back
right before y'all made discovery available. So state, just make sure that you all are making discovery available before that, because for a case to be indicted and you all hadn't made discovery available for 2 months, that's over. Yeah, that's a problem. Okay. All right. And Ms. Burris, because I didn't ask you a question. Do you have any questions about that?
Do I?
Okay. I'm talking to Ms. Burris, Mr. Duplantis. Okay. All right. So with that being said, the offer that was extended November of 2021, counsel, what's your client's position on the offer?
Your Honor, I don't recall ever having been given an offer.
Ms. Burris, do you all convey the offers in the system that you all use?
Correct, Your Honor. It's on TechShare.
I'm looking at it right now. I don't see it.
I am re-extending it.
Okay, cool.
Okay, so attorneys, Mr. Duplantis and Ms. Burris, when you all know you're being set for a status, which you all did know, then the court's expectation is that you all have talked before. So then you all would have known this before I asked today if an offer had been tendered, if you didn't receive it. So you all can't have these conversations for the first time with the court. You all have to have substantive conversations before the court date. Okay, do I have any questions about that?
No, Your Honor.
Okay. All right, so you all need to reset Dixon, and I'm gonna give you all a short date because it seems like you all are not utilizing the long dates. I'll give you all February 1st for your next date, and it's a status. The court's expectation is that you all will have spoken before that date to work on the case. All right, Ms. Dixon, you will appear via Zoom the next time. Counsel has the link, so he'll send it to you. So don't wait till the day of to download the Zoom app, okay? Okay, thank you so much, Ms. Dixon. You're excused.
Thank you.
Can you give me that date again? You said February
2nd.
2nd.
First.
No, sorry, first.
February 1st. Okay. And Mr. Duplantis, I see you're remote. Would you like us to handle that pass slip for you? Or are you going to be at the conference to do it?
That would be fine. Thank you.
I can sign for you by permission?
Absolutely.
All right, perfect. You all are excused.
Thank you, Your Honor.
You're welcome. All right, Brian, did Delgadillo answer up?
No.
Okay.
Mark Delgadillo still has COVID. His counsel sent over proof of his test yesterday afternoon. I can put it in Teams for you if you'd like.
Please, yes, while we were in trial. Perfect.
And I don't know if Cynthia Barbary or Robert Simmons is in the waiting room.
No, they're not.
Okay, if not, then I can happily reset it and let them know.
Yeah, just send an email with everyone and RC will respond. She has email access now.
Okay. You should have the proof of his last test.
And then let's see. All right. So, Sheriff, do we have Dickerson up?
Yes, Judge.
Okay, don't pull him. His attorney's not on.
Okay.
All right, we're on the second page. Do we have Dunn?
Done, yes, Judge.
Okay, you can pull Dunn.
Okay. Done. What's the deal with this guy? He talking with the attorney.
I don't have another bill. I know it costs.
Yeah, we can use that.
And Brian, while he's doing that, can you call the hall for these people on the second page?
I'll have to wait for him to come back because we got this guy at the.
Oh, he's still at the thing with his attorney.
But what's the name, Judge?
Espinoza and Lee.
Okay.
All right, and then attorneys on Dunn. Is this probation or jail? And Mr. Guidry, if you're saying something, you're muted.
Probation, Your Honor.
Okay, and Ms. McKay, what's the TRAS and the rec?
We have nothing, Your Honor. We never received a personal data sheet
From the state?
Your Honor,
from the defense.
From defense?
from us. Your Honor, my client, we're getting that data sheet to probation today. I'm in a rehab right now. I had a full knee replacement with my assistant. She's getting that information today. She's going to get it over to probation.
So you all realize
Today.
you were set for a plea today, so you all should have done that already?
Now, I understand, Your Honor, but I went down and got a total knee replacement. So I got to take care of his health so I can get that done for Mr. Dunn.
You're absolutely right. I guess next time, if you can have your assistant do it, or you can email us, so then that way we could have already passed it and gotten you a date, because probation, I understand your health issue, probation is short-staffed. And so it's going to take a second to get your client. He's going to just sit in jail some more. All right, Ms. McKay, can you call and get him another date? or calling getting, oh, I'm sorry, you don't have an information sheet
I don't
still.
have, yeah.
Okay. Mr. Guidry, you said your assistant was bringing it when?
Today, she's actually gonna do the video conference with him today, do the video conference downstairs in Frank Crowley, and she's gonna get that information and bring it up to probation today.
Okay. So Mr. Guidry, let me explain something to you. It needed to
Yes,
be
ma'am.
done during docket because we're gonna give you a date today so that RC doesn't have to chase you all. So Miss McCabe, and I
Okay.
see her nodding her head, yes. So we don't have to chase y'all. We do it all at once, very efficient. So we get the information sheet from you, Miss McCabe calls, they give us the ready date, and then I give you the plea date. So to wait on somebody to do that afterwards, and then they have to circle the wagons, it's too much for us to have to do when we have other stuff to do after docket. So what we can do, because I don't want to give you a plea date that he's not going to be able to plea on because they still don't have the info from you all. Mr. Guidry, if you, once we finish, can log off and call your assistant, have her just go into the courthouse. He's in the holdover. She can get the form filled out right there, turn it in, and Miss McCabe can just call. Okay.
Yeah, I'm gonna call her right now, Your Honor, and tell her to get on it, and get that up to Mr. McKay, to the probation, and get that for you.
Yeah, before 11. It's 10:04.
Okay.
Okay.
Yes, ma'am. Will
Sheriff,
do.
hold him.
Yes, Judge.
Don't send him back.
Pretty good.
All right.
Hold on. Your Honor, please. If Mr. Dunn is there, can my client come to the courtroom, to the holdover, and get that information right there?
This is how I know y'all don't listen to me, because that's what I just said.
Okay. Oh yeah, because I'm still caught on the video
Right.
portion of my system. I'm
Yeah.
sorry. Yes, sir.
No, you're okay. I just said they're gonna hold him for your assistant to come into the courtroom.
Okay. All right.
Okay.
I'm gonna get on it right
Thank
now,
you.
Judge.
All right.
Thank you,
Bye-bye.
Judge. All right.
All right. So, Bram, are they finished at the alternate screen?
Along with his one, I'm not sure. She'll probably be in there now. Say that again, Judge.
Are they finished at the alternate screen?
Yes.
Okay. So let's see if Espinoza and Lee, Espinoza's up. So if Lee is out there, just let Lee sit and ask them where their attorney is. But
Okay.
Espinoza's actually up.
Okay. Is she done? Oh, okay.
Judge Espinoza is Annalise. I don't know if she's in the waiting room.
She's not.
Okay, I'll send her a message.
Okay.
Okay, Judge, I'm gonna go do those calls right now.
Thank you.
Judge Espinoza nor Lee answered at 10:06.
Thank you, Brian.
Carol. Oh, okay. Thank you.
Sheriff, do we have Gooden up?
Say that name one more time.
Gooden.
See that name on the chain, Judge.
Okay.
Gooden, it looks like is set for an announcement and we have a ready date.
Hold on, counsel. His attorney's trying to connect her audio. All right, attorneys on Graves. Mr. Edwards, did you just unmute yourself?
I did.
Okay. So it looks like you all didn't turn in a passive last setting to RC. Where are you all at in the case? Do you have discovery and an offer?
I do. Defense made a counter offer via email. And let me just say, it was 100% defense's fault for not getting that pass slip done. However, there was a counter offer via email and just waiting for a response from the state.
Okay. And Mr. Edwards, I appreciate you taking the blame for it, but really you all need to apologize to RC for not doing it because it makes extra work for her. She has to send you an email to tell you that you didn't show up when you know that you didn't turn in the pass slip, and then she has to set it for you. So it's just additional work because she has other stuff to do. So just make sure you all get that simple paper pass slip in, okay?
Yes, Your Honor.
Okay.
Sherrod, I'm sure that you did send me an email that's buried under about 300 others. Can you resend that to me, whatever that was, if I have not responded?
Sure.
Okay.
I can.
Thank you.
And so I'm going to set you up for a status on February 1st. So please turn in a paper pass slip today for Graves.
Okay,
And then,
thank you,
Mr.
Judge.
Edwards, do you have anything else on today's docket?
I do not.
Okay, thank you.
Thank you.
Mr.
Sheriff,
Edwards,
we have Graves, he can go back.
Okay.
can you sign the pass slip for me, Mr. Edwards,
Okay.
just by permission?
Yes,
Thank
I
you.
will.
You ready? Okay.
So is he done at the computer right now?
He will be in like 2 seconds.
Okay.
Okay. This right here, we talked to someone, you're expected to report, you know, it's now when you report at 4 o'clock. So this is the address and the phone number, it's all But I'm gonna leave this with you, and it has all three of them. I got some. Like 2 weeks ago, when your first meeting was. I'm gonna stick this one in your pocket, okay?
All right, Bram, do we have Hale?
What's her name again, Judge?
Hale on the second page?
Not on the jail chain.
Okay. Do we have Heimerman?
Heimerman, not on the jail chain.
Okay. Sprinter. And all right, Bram, on the third page, if you can call the hall for Marshall.
Marshall.
And Patternite.
Okay.
And Rodriguez. And Marshall is up. So if Patternite and Rodriguez are outside, leave them out there and just tell them to let their attorneys know that we're on their page.
Okay. Marshall didn't sign in, but the other two did, so I'll check again.
Okay, thank you. And then other sheriff's officer in the courtroom, I'm sorry, I didn't catch your name.
The name. It's Deputy Vance.
Oh, Deputy Vance, can you pull Luna? Do you all have Luna?
I'm sorry, which one you're on?
Luna?
We don't have Luna on the chain.
Oh, no, we don't have them.
Okay. Do you have Riney?
No, you're on.
Okay. And Rogers?
Did you say Rogers?
Yes,
I have a Brian Thomas Rogers.
Okay, you have him on the chain?
Yes, ma'am.
Okay, don't pull him. His attorney's not on. Okay, that is the third page. And do you have Walker up?
I do, Your Honor.
Okay, go ahead, please, and pull Walker.
Walker? Okay.
Cody Carroll, he's done, he can go back.
Sorry.
Carroll's done, Carroll go back, yes, sir. Thank you.
All right, attorneys on Walker. Is this a probation plea or jail plea? Hold on, you all. You all can stay right there. But Ms. Martin and the state on Walker, is this jail or probation?
It's a probation plea.
Okay. Ms. Martin, go ahead and black your camera out and mute for me.
Yes, ma'am.
And then counsel, What is your name and your client's name?
Us?
Yes.
Frank Sellers here with Gary Patternite.
Okay. And Mr. Sellers, please put your mask back on. You can take it off when you get outside the courtroom if you choose to.
Sure.
All right. Now, on pattern night, say when was the initial offer conveyed? When was discovery made available? And when was the case indicted?
Judge, the case was indicted on July 28th, 2021. The first plea offer was issued on September 8th, 2021. Discovery was provided in August. However, the reason this got set on the status hearing docket is because counsel said he was missing evidence. I did confirm with the law enforcement agency that they had not given us everything. They provided that information to us last week. Because of the nature of the evidence with the explicit images, it's on a dirty laptop here in our office, so counsel will have to come and make an appointment to view it. Which they provided late last week, so that has not been coordinated yet with my investigator. Once they're able to view the evidence and we're able to have some substantive discussions, I think we'll be able to move the case forward.
Okay. How soon are they giving appointments, State?
So my investigator has been out this week. He returns on Monday. Once he comes back in, all they have to do is email him and he can get them an appointment as soon as they're available.
Okay. So counsel, you're going to send the email on the 31st so that you can get the first available appointment. And then I am going to set you all for, so please put that on the pass slip, DC to send email to schedule with investigator by January 31st or on January 31st. And then your plea, or excuse me, your setting for a status will be on February 7th.
We've already sent requesting the appointment, Your Honor.
Okay. Just forward it for him on the 31st, since if he's been out, you don't want yours to get lost. Okay. And that should be simple since you already sent it. And then let's see, Mr. Patternite, you will log on to Zoom for that status. So check off Zoom status, or it really will say other, and put Zoom status so that I know not to call the hall for him. Okay. And then you all please make sure you get that paper pass slip in. Was there anything else?
This is reset to when, Your Honor?
February 7th for a status.
Well, Your Honor, that's like 10
I
business.
hear you, counsel, and I'm setting you for a status. You can be on Zoom if you choose.
Well, I just want to be able to get over here to view what we need to view. And he's not even
right. I'm making sure that you all actually meet up or that you're on a calendar, counsel. It's the court's prerogative. I will see you back via Zoom on February 7th.
All right.
Thank you.
May we be excused?
You are, in fact, counsel.
Mr. Sellers, you can sign for me on that pass slip.
Thank you, Kristen.
Thank you.
So Marshall didn't sign, didn't check in. Didn't answer up when you called the hall.
No.
Okay, what about Rodriguez?
Rodriguez, yes, Gilbert Rodriguez, he did.
Okay, and his attorney is on Zoom, so you can go ahead and have him sit inside the courtroom at the desk.
Okay. Just make sure it's cool off.
All right, Ms. Ohan, you're muted. Was it your intention to come inside the courtroom with your client? You're muted.
That next seat.
Sheriff, can you go ahead and print him while I'm looking at the paperwork?
Yes, Judge.
You know what? I'm sorry, I don't think there was a print sheet with all that stuff. Do y'all have one in here? You got it? Okay, great, thank you.
You gotta do it. Nah, work hard. Four fingers, press hard. You press right there.
Okay.
Yes. Good job.
All right, Lisa, let's go on the record. This is cause number F18-42418, styled the state of Texas versus Gilbert Rodriguez. Sir, is that your true and correct name?
Yes, ma'am.
Can you read and understand the English language?
Yes.
And appearances from counsel?
Rachel Burris for the state.
Nancy Ohan on behalf of Mr. Rodriguez.
And pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference is streaming on the YouTube account 282 Court that has been provided to the court by the Texas Office of Court Administration. And are both sides ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right, sir, the state has filed a motion to strike the enhancement paragraphs on the face of the indictment. So you were looking at a third-degree felony offense of driving while intoxicated. You're looking at 2 to 10 years in the penitentiary and up to an optional $10,000 fine. Do you understand that range of punishment?
Yes, ma'am. I do, Your Honor.
Did you read, did your lawyer explain to you, and did you understand every document you signed in this case, including the court's written admonishments regarding your constitutional and statutory rights?
Yes, Your Honor.
Are you satisfied that your attorneys fully investigated the case?
Yes, Your Honor.
And counsel, is your client competent to proceed?
Yes, Your Honor, he's competent.
Sir, do you understand that you have an absolute right to a jury trial under the constitutions of the U.S. and the state of Texas, the right to remain silent, and the right to confront and cross-examine your accusers?
Yes, Your Honor.
You understand that by entering into a plea today, you're waiving those rights?
Yes, I do, Your Honor.
The Michael Morton Act applies in this case. I have the discovery disclosure notice signed by yourself, your attorney, as well as the state. State, was this a BPD case impacted by the data loss?
No, Your Honor.
And counsel, are you satisfied that you received all discovery?
Yes, Your Honor, I am.
And do you wish to arraign your client?
Judge, we waive arraignment, enter a plea of guilty.
And sir, please raise your right hand. Do you judicially confess that you committed the offense exactly as alleged in the indictment with the exception of the 2 enhancement paragraphs?
Yes, Your Honor.
All right, you may lower your hand. And you've heard counsel enter a plea of guilty on your behalf. Is that your plea?
Yes, Your Honor.
Are you entering into that plea freely and voluntarily because you are guilty and for no other reason?
Yes, Your Honor.
I must admonish you, if you are not a U.S. citizen, there's a possibility that your plea of guilty can and will result in your deportation, exclusion from the country, and or denial of naturalization benefits. Do you understand that?
Yeah.
And with that understanding, do you still wish to proceed with your plea?
Yes, I do.
And state, please provide a synopsis of your probable cause affidavit.
On December 28th of 2018, officers in Mesquite, Texas were clearing a exit ramp that was being blocked. They were clearing it, got it cleared, and the vehicle that the defendant was in made an abrupt lane change, cutting across, all 4 lanes of travel, thus bringing his vehicle to their attention. They made contact, decided or noticed slurred speech, the odor of alcohol, did a field sobriety test, determined he was intoxicated, additionally did a blood draw once they got to jail that confirmed what they knew, and he has 2 prior DWI convictions to enhance him to the 3rd degree, giving this court jurisdiction.
And what was the reading?
I don't have that pulled up.
Okay, I'll give you time to do so.
Blood test, Judge?
I'm sorry?
Are you asking for the blood? Are you
Yes, the
asking?
results.
I believe it was a 0.2.
And state if you want to just check.
It was a 0.205, yes.
Okay. All right. And state you may proceed.
State offer states exhibit number 1, the defendant signed written voluntary judicial confession and stipulation of evidence. And state offer states exhibit number 2, the defendant's Michael Morton paperwork.
No objection.
State's exhibits are admitted.
State rests.
Rest, Judge.
State closes.
We close.
All right, sir, I accept your plea of guilty. I find that there's sufficient evidence to prove your guilt beyond a reasonable doubt. I will grant the party's request and accept your plea agreement. Pursuant to the plea agreement, I assess your punishment at 2 years confinement in the Texas Department of Criminal Justice. Counsel, is there any legal reason why sentence should not be imposed?
No, Your Honor.
It's the order, judgment, and decree of the court that you be taken by the sheriff to be authorized receiving agent of the Texas Department of Criminal Justice, where you shall serve a period of 2 years. Your sentence begins today. You'll receive all back time that you previously served. The court will now review with you the trial court certification of defendant's right of appeal. It reads the same at the top. It acknowledges that this is a criminal case, and there's a box checked off above the court signature that states that you waive your right to an appeal because you entered into a plea agreement. Do you understand that?
Yes, Your
Ms.
Honor.
Rodriguez? Okay. And then counsel, were you appointed or retained?
I'm retained, Judge.
And sir, how much time do you need to pay your court costs?
He's pretty much indigent, Judge. In fact, during the proceedings here with our involvement with the state, they got his family hooked up with food stamps and everything. It's going to be very difficult for his wife to actually hold on to their house when he goes into custody today.
What I can do is reduce them by half, and then I will give him until not on. I can't use my phone. Hold on, give me 1 second.
Would the court consider?
Give him until January 27th of 2024, and it's reduced by half.
And would the court consider at all maybe giving him his credit when he got arrested towards the court cost?
So by law, Article 4215 requires that I consider his financial status to determine court costs. So that's what I've done. So I've given you half of a court cost. So that's nice of the court to do. You're not indigent as defined by 4215. And I'm giving you 2 years to pay it. That's within my authority from Article 4215 of the code. Okay. So you all are welcome.
Judge, one housekeeping matter on this case, and that
Give me 1 second, counsel. Let me finish typing what I'm trying to type.
Sending me somewhere.
27, 24. And
coming in the courtroom?
No, coming to TDC.
Oh, she doesn't have anything to do with that.
And as far as the car, take that thing off.
That's what I'm about to ask her.
all right, counsel, you were saying?
Oh, I'm sorry, Judge. Thank you. I didn't realize you were done. Housekeeping matter in that Mr. Rodriguez has an interlock device on his car. His wife is here today. Would the court grant me leave to go to another judge to sign an interlock removal order, given the fact that Mr. Rodriguez is going into custody at this time?
Why would you need another judge to do it when I'm here?
Because I don't know that you're here.
But you don't have to, counsel. All you have to do is go get the form. I have an assistant who, even if I wasn't at the courthouse, right? Let's see, because you don't have to know that. But even if I wasn't at the courthouse, I could still get it signed for you. Okay. So if you go downstairs to pretrial and get the form, we'll get it signed for you. All right. Was there anything else that you needed?
That takes care of it, Judge. Thank you.
Okay. Thank you so much. Sheriff, do a dispo to follow on him. Okay. Thank you. And you all are excused. Let's go off the record.
Goodbye, Mr. Rodriguez.
All right, and then Sheriff, let's put Walker in the chair.
Judge, I'm coming down.
Okay, thank you.
Judge, do you have this paperwork or do I need to send this to you?
You'll need to send it every day that it's set.
Okay.
What happened to my phone? Say that again. What happened to my phone? So you go to my phone. They gonna keep it until you get out. So can I get out to the room? I'll look at it. See right here.
Okay.
You want me to sit in the other chair?
No, this your time?
Yeah.
Yeah. Shake that, Mr. Walker.
No problem.
Yeah, that's what I said. All right, you all, is Walker a probation plea or a jail plea?
Probation, Your Honor.
Okay, and Ms. McCabe or Mr. Atkins, what's the TRAS and any recs?
Judge, the rec is JTC Wilmer. And his score was a high, TRAS score.
Okay, any other recommendations besides Wilmer?
Let me check. Just 1 second, Judge. No alcohol. That's it, Judge.
Okay, thank you. Sheriff, can you print him twice while I'm looking at these packets?
Judge, we would like to put on some evidence, just asking for IOP instead of Wilmer.
That's fine. I need, Sheriff, go ahead and print him while I'm looking at these. I'll hear from you when you're on the record.
Yes, ma'am. Oh, for the, which hand did you use for this one? Kind of help. That's something. Yeah, that's it.
All right. Lisa, we can go on the record. These are clause numbers F21 6589, F21 52133, both still the state of Texas versus John Walker. And sir, is that your true and correct name?
Yes, ma'am.
And can you read and understand the English language?
Yes, ma'am.
And appearances from counsel?
Burris for the state.
Stephanie Martin for the defense.
All right, and pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference is streaming on the court's 282 court YouTube account that was created by the Office of Court of Administration. And counsel, state and defense, are you all ready to proceed on these, please?
Yes,
Yeah.
Your Honor.
Yes, Your Honor.
All right. Sir, in both of the cases, and I'm going to share my screen with you, and I'm going to use the 6589 as an example. All right. In both of the cases, you have waived your right to have a Dallas County grand jury review these cases. And I'm showing you defendant's waiver of indictment in the 6589 case. It looks the same in the 2133 with the exception of the cause numbers. And you understand that you have an absolute right to have a Dallas County grand jury review these matters, but you're waiving that right?
Yes, ma'am.
Okay, and that's evidenced by your signature that you see here to the right and your attorneys to the left, correct?
Yes, ma'am.
Actually,
Okay.
Judge, I signed that on behalf of my client. Considering that was already in the plea paperwork, I signed that on his behalf.
Okay,
And
so sir, you gave counsel permission to sign the plea paperwork on your behalf?
Yes, ma'am.
just that one page, Judge.
Okay, you understand that the signature that's on the waiver of indictment forms will be accepted as if it was your own.
Yes, ma'am.
Okay, perfect. All right. In both cases, the state has filed motions to strike the enhancement paragraphs and the disaster paragraphs, and that is granted by the court. So in the 2133, the state is proceeding with a third degree unlawful possession of a firearm by a felon. You're looking at 2 to 10 years in the penitentiary on that cause. And in the 6589, a state jail theft. So you're looking at 180 days to 2 years confinement in the state jail facility on that cause, and on both up to an optional $10,000 fine. Do you understand those ranges of punishment?
Yes, ma'am.
Did you read? Did your lawyer explain to you? And did you understand every document you sign in these cases, including the court's written admonishments regarding your constitutional and statutory rights?
Yes, ma'am.
Are you satisfied that your attorneys fully investigated the cases?
Yes, ma'am.
Have you read and reviewed the charging instruments with your attorney?
Yes, ma'am.
And counsel, is your client competent to proceed?
Yes, Your Honor.
Sir, do you understand that you have an absolute right to have a jury trial pursuant to the U.S. Constitution and that of the state of Texas, the right to remain silent, and the right to confront and cross-examine your accusers?
Yes, ma'am.
You understand that by entering into a plea today, you're waiving those rights?
Yes, ma'am.
The Michael Morton Act applies in this case. I have, and actually in both cases, I have the discovery disclosure notices signed by yourself, your attorney, as well as the state. State, were these DPD cases that were impacted by the data loss?
No, Your Honor.
And counsel, are you satisfied that you received all discovery?
Yes, Your Honor.
And do you wish to arraign your client?
No, Your Honor. Comes now the defendant states his true and correct name is John Walker. He is one and the same person charged in the indictment in the first case and complaint and information in the second case. He waives formal reading of those instruments and enters his plea of guilty to both.
All right, sir. And as best as you can, please raise your right hand. Do you judicially confess that you commit the offense exactly, or offenses, excuse me, exactly as alleged in the indictment with the exception of the enhancement paragraphs?
Yes, ma'am.
All right, you may lower your hand. You've also heard counsel enter pleas of guilty on your behalf. Are those your pleas?
Yes, ma'am.
And are you entering into those pleas freely and voluntarily because you are guilty and for no other reason?
Yes, ma'am.
I must admonish you, if you are not a U.S. citizen, there's a possibility that your plea of guilty can and will result in your deportation, exclusion from the country, and or denial of naturalization benefits. Do you understand that?
Yes, ma'am.
And with that understanding, do you still wish to proceed with your plea?
Yes, ma'am.
And state, please provide a synopsis of your probable cause affidavits.
In the case ending in 8-9, officers noticed 2 males, one identified as the defendant, walking around several parked school buses near the rear of the lot. They noticed that they were carrying large cut catalytic converters and work gloves. saw the defendant crouching behind the bus, ordered him out, and he was subsequently arrested. In the cause ending in 3-3, officers observed a vehicle commit multiple traffic violations, made a subsequent traffic stop. As they approached the vehicle, they could smell marijuana. They asked him to exit the vehicle. A search of the vehicle was done, locating a 9mm handgun in the passenger seat. He was arrested and subsequently charged with that because he did have a prior conviction for burglary of a habitation.
And was that it, State?
That was it, Your Honor.
Okay, you may proceed.
State offer State's Exhibit number 1, the defendant signed written voluntary judicial confession in each case. And State offer State's Exhibit number 2, the defendant signed Michael Morton paperwork in each case.
No objection.
And State, what is the MMA paperwork offered as?
State's Exhibit 2, I apologize if I didn't say that.
Okay. States 1 and 2 are admitted in both causes?
State
No.
rest.
I'm sorry, Judge. Your Honor, I would call my client just for the purpose of one of the conditions of probation.
You're calling your client to testify?
Yes, Your Honor.
Okay. So, sir, please raise your right hand again. You solemnly swear or affirm that the testimony you'll provide in these causes will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, counsel, you may proceed.
Thank you, Your Honor. Mr. Walker, you and I have talked at length with regard to when the drug evaluation came back today. Is that right?
Yes, ma'am.
And we talked about that the report indicates that they want you to go to Wilmer. And have you ever done any kind of drug treatment before?
No, ma'am.
No. And how long has it been since you've used anything?
Over 2 years.
Have you, for the most part, got a pretty good handle on, as of today, your drug use?
Yes, ma'am.
You understand that as someone who uses drugs or who's addicted to drugs, it's recovery, it's not a cure, right?
Yes, ma'am.
And at this point, are you asking the judge to give you outpatient?
Yes, ma'am.
All right, let's talk just a little bit about your household. Are you married?
Yes, ma'am.
How long have you been with your wife?
Going on 6 years.
All right, and do you have children?
Yes, ma'am.
What age range are your children?
19, 13, and 7.
All right, and are they girls, boys?
All girls.
Do they live with you?
Yes, ma'am.
In fact, do you have a grandbaby now?
Yes, just have a grandbaby, 2 months old.
All right, and does the grandbaby live with you at your household too?
Yes, ma'am.
Is your wife working?
No, ma'am. She disability, have arthritis in her spine.
Okay. Before you got picked up on these cases, on this last case, were you working?
Yes, ma'am.
What kind of job were you doing?
Remodeling houses.
In fact, there's a pretty big push for people to do that job right now. Isn't that right?
Yes, ma'am.
When you get out, do you feel confident that you'll be able to get right back into that?
Yes, ma'am.
So you'll have gainful employment for that.
Yes, ma'am. Still waiting on me.
They're still waiting on you. All right. Are you committed to staying sober?
Yes, ma'am.
In fact, one of the conditions that the prosecutors asked for was a drug patch.
Yes,
Is that
ma'am.
right?
Yes, ma'am.
And you're willing to do the drug patch?
Yes, ma'am.
Is it important that you get home as quick as possible to try to help with your finances at your house?
Yes, ma'am.
Are they struggling since you've been locked up?
Yes, ma'am.
Is there anything else you'd like have we covered everything that we've talked about that we think the judge needed to hear?
I mean, my wife leave me. She have high blood pressure. You know what I'm saying? She in and out the hospital. You know what I'm saying? And I'm really a big responsibility to the house as far as paying bills.
Mm-hmm. And you realize, I mean, you put yourself in this situation, right?
Yes, ma'am.
And are you tired of committing crimes?
Yes, ma'am.
You ready to take this probation and really
And run
do
with it.
right?
Yes,
Okay.
ma'am.
And we've talked about that for quite a while, right?
Yes, ma'am. And
Thank
plus, I have a grandbaby too.
Right. And I mean, you got a 2-month-old at the house.
Yes, ma'am.
All right. Thank you. I'll pass the witness.
State.
No questions, Your Honor.
I have some questions. So I'm looking at the forensic clinical evaluation. The date of the evaluation was December 2nd of 2021. The date of the report is December 14th, 2021. Both state and defense, you all have reviewed this document?
Not the one from 2021, Judge.
Okay.
Oh, yes, Judge, from 2021, yes. December 14th,
Okay.
what you said?
So it said the interview was 12/2/21. The date of the report is 12/14/21.
Yes, Your Honor.
Okay, perfect. And state, have you looked at it?
I have not, but I believe Miss Moore, who's on it, has looked at it, and I know that she had, she did not have strong feelings about that one way or the other.
Okay. So state, since you're the one on the record and you haven't reviewed it, I'm going to give you time to look at it. It's 7 pages.
Okay.
All right. So let me know when you're finished looking at it.
I have a copy. I can take it to her really quick.
I don't know if she's virtual or not.
Oh, I'm sorry.
Yeah, she's virtual. So, all right. Okay. So Ms. McCabe, you can send it to her if she doesn't already have it. And then Ms. Martin, you all, Sheriff, we can put him in the back, and Ms. Martin, you can take a seat in the back, okay,
Yep.
behind the bar or outside, either way. Let's go off the record. All right, so that's one full call of today's docket. We're going to start on second calls. And Brahim, do we have Bonkowski?
Yes, Judge.
Okay, you can pull him.
Barkowski.
Judge, I think Bonkowski is Mr. Franks. I sent her a message. I didn't know if you'd seen her in the waiting
Yeah,
room.
she just logged in. I see her. All right, Mr. Lacy, if you can unmute yourself for me.
Good morning, Your Honor.
Good morning. And were you coming into the courtroom with your client?
So my client is he's currently in jail, so he should be on a jail chain. I'm actually
No. No, I'm asking you, were you coming inside the 282nd with your client?
I can
Or
do
you
that,
staying
Your
on
Honor.
Zoom? Okay. If you want to go ahead and head up while
No,
they're pulling.
I actually prefer. Okay.
And then Ms. Burrs, who's the prosecutor on? You said it was Annalise on Bonkowski?
Yes, Your Honor.
Okay.
Good morning, Judge.
Good morning. Graham, his attorney's supposed to be coming down there. Where I don't know where he was in the courthouse.
Your attorney coming in.
Okay.
Right. Let's see, where was he in the courthouse? All right, Graham, we'll do a third call on him.
Oh, put it on. Yeah, he was supposed to be on the way down.
We're gonna do a second call on Coggins, Graham.
Coggins, okay, we ready. Coggins, come on.
Ms. Burris, you may want to check on Ms. Patterson. It says she's been joining for a second now.
Okay, Your Honor.
There she is. All right. So Mr. K and Ms. Patterson, are you all ready for your second call now?
Yes, Your Honor.
Okay. And Ms. McCabe, you said his TRAS was moderate and he didn't have any recommendations?
Correct, Judge.
Okay. State and defense, what was the relationship between the accused and the complaining witness?
Mother and son.
And what's the address that he gave to probation? Was it his mom's address?
No, Your Honor, we have a new address for him and.
Okay, you don't have to give it the
Okay.
exact address. I want to just make sure. And Mr. K, you want to unmute yourself so that you can participate. All right. And so who is he going to be living with now?
And I don't know who lives at that address.
No, I'm waiting on Mr. K to unmute. He's unmuted now.
Mr. Coggins, that's your own apartment or your wife's apartment? I'm not 100% sure of that address.
The house, my wife, my son live there.
Okay. And Ms. McCabe, he screened out of anything?
Yes, Judge, that's what it's saying.
Okay. All right. All right, Lisa, let's go on the record. This is cause number F21-34134, Sell the State of Texas versus Christopher Coggins. Sir, is that your true and correct name?
Yes,
And can you read and understand the English language?
yes,
And appearances from counsel?
Alicia Patterson for the state.
Bruce K for defendant.
All right, and pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference is streaming on the 280 Seconds YouTube account that was provided to the court by the Office of Court Administration. And counsel, I see that you're virtual as well. Is that correct?
Yes, Your Honor.
Okay. And are both sides ready to proceed with the agreed plea?
Yes, Your
Yes,
Honor.
Your Honor.
And sir, you are charged by indictment with the third-degree felony offense of injury, to an elderly individual. And you're looking at 2 to 10 years in the penitentiary and up to an optional $10,000 fine. Do you understand that range of punishment?
yes,
Did you read? Did your lawyer explain to you? And did you understand every document you signed in this case, including the court's written admonishments regarding your constitutional and statutory rights?
yes,
Are you satisfied that your attorneys fully investigated the case?
yes,
Have you read and reviewed the indictment with your lawyer?
yes,
Counsel, is your client competent to proceed?
Yes, Your Honor.
Sir, do you understand that you have an absolute right to a jury trial under the constitutions of the U.S. and the state of Texas, the right to remain silent, and the right to confront and cross-examine your accusers?
yes,
You understand that by entering into a plea today, you're waiving those rights?
yes,
The Michael Morton Act applies in this case. I have the discovery disclosure notice signed by yourself, your attorney, as well as the state. State, was this a DPD case impacted by the data loss?
No, Your Honor.
And counsel, are you satisfied that you received all discovery?
Yes.
And do you wish to arraign your client?
We'll waive arraignment. Comes now Christopher Coggins, states he is the same person named in the cause of action and indictment. Waives presentation of the indictment and reading of it all, and hereby enters a plea of guilty to the charged offense.
And sir, please raise your right hand as best as you can. Are you cuffed and you can't?
yes, yes,
Okay. Okay, as best as you can. All right. Do you judicially, confess that you committed the offense exactly as alleged in the indictment in this cause?
yes,
Okay, you can lower your hand. And you've heard counsel enter a plea of guilty on your behalf. Is that your plea?
yes,
Are you entering into that plea freely and voluntarily because you are guilty and for no other reason?
yes,
I must admonish you, if you are not a U.S. citizen, there's a possibility that your plea of guilty can and will result in your deportation, exclusion from the country, and or denial of naturalization benefits. Do you understand that?
yes,
And with that understanding, do you still wish to proceed with your plea?
yes.
And state, please provide a synopsis of your probable cause affidavit.
On June 23rd of 2021, his mother, Laverne Coggins, was pushed by the defendant, Christopher Coggins, a few times, causing her injury. There was also a misdemeanor case filed for unlawful restraint. This occurred at the mother's house. The state will be dismissing the misdemeanor charge when he pleads guilty to the felony.
All right, and state, please proceed.
Your Honor, the state offers State's Exhibit Number 1, the defendant's signed, written, and voluntary judicial confession and stipulation of evidence, and State's Exhibit Number 2, all signed paperwork in accordance with the Michael Morton Act.
We have no objection, Your Honor.
State's exhibits are admitted.
State rest and close, Your Honor.
As we do too.
Sir, I accept your plea of guilty. I find that there's sufficient evidence to prove your guilt beyond a reasonable doubt. Pursuant to Article 42A.301, subsection A of the code, we do have your risk assessment. You're listed as a low risk. With that, I will accept the party's plea agreement. And in doing so, I'll defer adjudication of your guilt and place you on community supervision for a period of 2 years. There are 2 things you need to understand about being placed on deferred. You do have the right to petition the court for an order of non-disclosure. The only reason you would not be eligible is because of the offense you pled to today and any prior criminal history you might have. Second thing, the full range of punishment that the court reviewed with you at the beginning of the plea is available to the court should you violate your terms of probation. Do you understand both of those things?
Yes.
All right. And then there's an affirmative finding of family violence in this case. I'm going to share the court screen and what we're going to be looking at. Is this document here entitled Defendant's Sworn Statement of Possession of Firearms, Ammunition, and/or Concealed Weapons Permit. There is a address here. This is not your mom's address, correct?
That's my home address where I live.
Okay. And then you've signed it as well as your attorney. So you understand your obligation that you cannot possess a firearm, and it's a federal offense for you to ask someone to purchase one for you. You understand that?
Yes.
Okay. You also understand that you can't even hold a weapon for anybody. So nobody can drop it off at the house and say, I'll be back next week to pick it up. You understand that?
Yes.
Okay.
Mr.
Now,
Coggins? Sorry.
I am going to order a psych eval, Ms. McCabe, and Mr. Coggins, you must have that psych eval completed within 4 weeks from your release. Ms. McCabe, I want him to check in. When he gets the psych eval, Ms. McCabe, will they forward the report to you all?
I am not sure of that, but I can check on that, Judge.
Okay, yeah, if you can check on that for me, because what I want is for him to come in the week that the report is generated so you all can address the contents of the report with him.
Yes, ma'am.
So if you can make a notation of that and make that one of his conditions of probation. Mr. Coggins, have you ever received any type of treatment prior to your arrest?
No.
Okay.
Treatment for what?
Just anything, any mental or health condition?
No.
Okay. All right. And do me a favor, Sheriff, can you all, if you all have a glove, can you cover his nose with his mask? Because he couldn't raise his right hand to be sworn. Thank you, Brian.
Thanks.
All right. I am going to review with you the trial court certification of defendant's right of appeal. It reads the same at the top. It acknowledges that this is a criminal case, and there's a box checked off above the court signature that states that you waive your right to an appeal because you entered into a plea agreement. Do you understand that?
Yes.
Okay. You're going to get your conditions of probation today. Please make sure you understand everything that's expected of you. Mr. Coggins, is there anything other than the psych eval that I've ordered that you think you might need to succeed on the probation?
I'm not sure about that question there.
Okay. Anything, I know some people think a judge is asking me what I need. That's my question to you, but you think on it. If you think of something that you think you might need to help you on this probation, let me know. Ms. McCabe, I'm also going to add a psychologist once a month. So what that means, Mr. Coggins, is you can pick your own psychologist. You just need to see that person once a month, and you'll need to submit proof to your field officer that you are actually seeing a psychologist once a month. Okay, we don't want to know what you talk about. Doesn't matter to me. I just need you to have the added support. Okay.
Okay.
All right. And then, counsel, were you appointed or retained?
I was appointed, and Judge, I'm not sure if he has insurance. So will the probation department be able to set him up with a counselor perhaps as a condition so that
I'm working on a partnership with an organization that it's a nonprofit. So worst case scenario, if he doesn't, I know that there are options out there for people that don't have health insurance. And the psych eval actually might assist him in that. Okay. So worst case scenario, Mr. Coggins, you can come back. I actually have a meeting with the organization again this week. So I'm hoping to start the pilot soon where we can offer free services like that to you. Okay. Because the state of Texas doesn't, meaning the state of Texas, the probation department, their budget's been cut. So they don't have anything free to offer like that. Okay. But we can work around it. Okay.
I can't really afford to see a psychologist right now, any money, so start
Right.
working.
You're going to work on it. You can do research on your own about services. Okay. So you're going to hold yourself accountable. You can do the research. Okay. You're going to come back when you get the psych eval and you're going to talk to Ms. McCabe about the research that you have done because you're going to be a part of this process, not just a bystander. Okay. So you can do that. That won't hurt you. Okay. All right. Now, Sheriff,
Thank
let's
you
make
for
sure
addressing that.
you're welcome. Now, back to my question, because I was asking about you being appointed. And then Mr. Coggins, has your financial status changed since you were appointed counsel?
No.
Okay, pursuant to Article 4215 of the code, I'm going to waive your court costs. And then you were to have no contact with Laverne Coggins. I understand I asked the question in the presence of your attorney and the state off the record, and that's your mother. So I can't think of a holiday that's coming up, but if you all are at a family function of some sort and your mom is there, she doesn't have to leave, but you do. Do you understand that?
Yes.
Okay. All right. Sheriff, let's hold him for probation. And then attorneys, you all are excused. Let's go off the record.
Thank you, Judge.
You're
Thank you,
welcome.
Your Honor.
And Brian, remember, Cooper Garrett is a BF for today.
Okay.
And Delgadillo, oh, that was the one that Ms. Van Bolden said had. Okay. And Mr. Schottmeyer has not appeared. And Brahim, did somebody come see Dunn already?
Yes.
Okay, Ms. McCabe, did they give you the sheet?
No, ma'am. The assistant said something else came up and she was gonna have to call Mr. Guidry or talk to the DA. That's what she told me.
Chasing folks. Okay. Ms. McCabe, can you send an email to that effect to defense, the state, the court, and me? Okay, and I'll respond to it.
Yes, ma'am.
Say what you just told me.
Yes, ma'am.
Okay, thank you.
I'll let her know you was here, so she'll let me know.
And Brahim, Espinoza didn't answer, right?
No.
Okay. All right, Ms. Burris, if you can activate your camera, please. All right, Ms. Baston, I see that you have Gooden on today.
Yes, Your Honor.
What's going on with Gooden?
Your Honor, I was requesting a bond hearing on my client. She's been in jail since November 8th, 2021. And I was requesting a bond amount in the amount of $1,500 on both of her cases that are pending in your court.
Okay. So it looks like y'all are set for an announcement. So she's not on the jail chain today.
Okay.
Let's see what we can do. I know tomorrow is not packed. And I know you had some audio issues before because your audio was just spinning, but you were here with us. If you want to, you can set it for tomorrow for the bond hearing.
Okay.
Okay. And then RC will put Gooden, excuse me, on the jail chain. So if you all just turn in a pass to put the 2 cause numbers on there and put bond hearing, then I can hear the evidence tomorrow.
Okay. Thank you, Your Honor. And then, Your Honor, I'm here also for attorney Anthony Farmer. He had to go to a funeral and he understands that the court was in trial most of this week, but he has a matter where he is asking for his client Tangela Woods to be able to go to Oklahoma City tomorrow for the funeral of her uncle.
Is she on probation or is just a new case?
Well, it's a motion to revoke her probation. That's the pending matter in your court. And Asia Reed is the prosecutor on the case. Jacqueline Leach is the pretrial officer. And it's my understanding that he has talked to both probation, pretrial and Miss Reed, and they do not have an issue with it, but we're bringing this before the court to see if the court would give her permission to travel to Oklahoma City tomorrow for her uncle's funeral.
Ms. McCabe or Mr. Atkins?
Yes, Judge.
Counsel, can you give them the clause number?
Yes, Your Honor. It's F16 00260.
Okay, I have it up.
Okay. Mr. Atkins, can you check to see if there are any issues ongoing with her while she has this pending motion?
Judge, you ordered a mod order on January 7th where her restitution was to be paid in full by January 31st. You had set a payment schedule as well.
Mm-hmm.
And as of now, she still owes.
How many of the scheduled, because I know I gave her specific days to come.
Yes,
How many
ma'am.
of those has she missed?
She has made 5 payments since then, totaling 631.
Oh, so she hasn't missed any of the appointments that she was supposed to make the payments.
Let me check, Judge.
Blood pressure. My body weight, everything.
That's correct. She's made payments by the deadlines.
Okay, that's fine. So permission for her to travel is granted.
Okay, thank you, Your Honor. I have the docket sheet. Do I just need to give it to Miss Warfield?
Let me check. Hold on. Because I just saw it. Her last name was Woods. I'll just respond to the email with everybody on it.
Okay, thank you, Your Honor.
If I can find it. And let Mr. Farmer know that RC hasn't had email access since Tuesday. So if you all were sending her emails, she wasn't ignoring you. She just couldn't respond.
All right, I will let Mr. Farmer know, but we also know that this court was in trial most of the week as well.
Thank you. Let's see.
I take it you're waiting for the judge too.
Actually, Mr. Schottmeyer, we've been waiting on you all morning.
Sorry, Judge, I've been in juvenile.
So you don't start with the whole I'm waiting on the judge. You on your second call on all of your cases.
Your Honor. Well, I'm getting on right now. It's good to see this fresh smiling face here.
Yeah. You're not even logged on. Boy, I tell you.
Dog, am I in the doghouse, Judge?
Oh, I don't have a doghouse. It's just blessings on top of blessings on top of blessings.
Well, I will be logging on right now, Your Honor. I just got back.
And we're about to take a break.
Oh.
All right. So, Ms. Baston, you're good to go. Everybody else, we're going to take a 10-minute break. So we'll see y'all back.
Thank you, Judge.
you.
Mark here, he knows that goes back.
All right, Bram, I see Mr. Nawawi, but y'all are muted. And state who's on the Raynell Jordan case?
Ready for you. Okay, sure.
All right, so you all are here because it looks like RC didn't get a pass slip from you all. Where are you all at on the Jordan case?
Good morning, Judge.
Good morning.
Judge, the probation, I spoke to probation, the offer is safety. My client does not want to go to safety, so the DA has just told me that the option would be either to go open to you. But probation is offering safety at this point on a motion.
Yeah, so it's always the court's discretion of whether or not to order the recommendations of probation. So it's not something that the state can order. So you all want to go ahead and set it so you all can present evidence about why an alternative means should be ordered.
Sure, Judge.
Okay, because y'all are on 17 settings, so let's see.
Do I just go get a date with the DA or do you give us a date?
No, I give you a date.
Okay, sure.
Let's see. Yeah, we're going to set you for the 4th of February.
Judge, I have a conflict on that day, Judge. I have a pre-trial in the juvenile court, 9:30.
Okay. Well, we'll be starting at 9 and then we go until 12. So they typically, are you in the master court or are you in the other court?
I'm in the district court.
Okay. Well, their dockets typically start early and run fast. So we'll still leave you because she's got too many settings or he has too many settings. Okay. So 2, 4, and then worst case scenario, you all will be closer towards 11. Okay. All right. If you all can get that paper pass slip in for me.
Yes, I will.
Just for clarity's sake, is this an open or a contested hearing?
It's open as to the conditions of probation because you all can't order somebody to go to safety. So if it's deferred, then he's asking for an alternative to the inpatient.
Yes, Your Honor, it's a PV. So that's why I'm just asking
Okay.
if the defense is going to contest the allegations or go open on the allegations since it's going to be a hearing.
Counsel, you didn't say anything about contesting the allegations, just the rec. So is it going to be agreed with the exception of the one condition?
Yes, Judge. I think.
Okay, so you're just going to go open as to treatment, but you're not contesting the allegations in the motion.
Judge, if I may, can I take a moment just to confer with my client who's here?
Uh-huh.
I don't know, is there a way to mute?
Yes, let me mute you.
Okay, sure. Yes, Judge. We are not going to be contesting the allegations. The hearing is going to just to determine what happens to him.
Okay. All right. So go ahead and set it for 2-4. Please turn in a paper pass slip. The bin is right there by the clerks, and then you all are excused.
Okay. But before I leave, since my client is here, he just gave me a piece of paper, and that's motion to reduce state jail felony to misdemeanor.
Okay, you can talk to the state about that, because that's something that will go into you all's plea negotiations. So
absolutely, Judge. Thank you.
Since it's a PV. Okay.
But he wanted me to make sure I give it to you. So
he can't give it to, since he has counsel, there's no pro se motion. So counsel, if you want to file it, great. If you want to talk to the state about, even though it's a PV, going back and making a change, if it was a deferred, so.
All right, thank you.
Thank you.
Thanks.
Raymond, do you all have Rogers?
Yes.
You say yes?
Yes, we do.
Hold on. I don't know why I'm getting feedback. It sounds weird. Did you all say yes, you have him?
Yes.
Okay. All right. Thanks, Darcy.
You ready for it?
Yes, Ms. McIntosh, you're on your second call on Rogers, your 3 cases. Can you unmute yourself for me?
Yes, Judge. I was just retained like maybe 2 weeks ago.
Yeah, y'all are set today for a plea. So you weren't the one that signed that pass slip?
No, I was not.
Okay. So are these PVs, Ms. Burris, or new cases?
One is a new case and 2 are PVs, if I'm not mistaken, Judge.
Okay. And so state and defense, what conversation have you all had about the cases?
Very minimum. I talked to Jennifer this morning, but I know it was in the middle of docket, that I wanted to discuss further this new case. And so we've been unable to just fully exhaust a discussion, Your Honor.
Okay. Well, so this new case is set 6 times, y'all. So is there not an offer on the case, Ms. Burris?
There's an offer, Your Honor.
Okay. And so
the offer was ended in February, or I'm sorry, in early December 2nd, but I know that Ms. McIntosh hasn't been on the case, but for a couple of weeks, so.
Okay. So Ms. McIntosh, if you can make sure, since you're there, because Jennifer's not present in virtual court, you can go ahead and have a conversation with her, because the PVs definitely need to be addressed. And if he has 6 settings, I know you've been hired for less than a month. We need to make sure that you all are in full communication before these dockets, because those conversations need to happen, not necessarily on docket day, but before.
Right.
Okay. So I'm going to give you all a short set of February 1st. Please make sure, Ms. Burris, that Jennifer and defense have, that there's some communication, at least on the state side, that you're responsible for, Ms. McIntosh on your side. Okay.
Okay.
All right. So February 1st for a status. And then you all are excused.
Okay. Thank you, Judge.
Thank you.
The question is, did you violate your probation? Did you not violate your probation? The answer is yes.
Judge Gibbons, could I pop in and ask a quick question?
Give me 1 second. Sheriff, is Mr. Lacy in there?
Yes.
Okay, he can have a seat at the table. You can pull Bonkowski for his third call. And then state whoever is on Ava Thompson, we need to talk. It's on the 4th page of the docket, and it's Mr. Lacy's case. All right, Ms. Van Bolden.
Yes, Judge. As you know, I'm new to child abuse. I have pled some cases in your court, and I learned recently that lifetime protective orders are required for some of these cases by a new statute. From my understanding, the way that we have to get that done, the defense attorney, of course, can agree to it. They have to physically serve the papers to the defendant, have them sign. They can't have signed by permission. And then the paperwork needs to be signed by the court. Is that something that we could do? In particular, one for next Friday. It's a case I pled last week, I believe.
Well, send the email to the court and defense counsel, and we can talk via email since they're not here.
Okay.
Okay. All right. You all, let's talk about Thompson real quick. You all have 16 settings on Thompson. State, when was the offer conveyed on Thompson and discovery and the indictment?
So Judge, the indictment came down December 18th of 2019. The offer was conveyed on 2/17 of 2020, and discovery was opened beginning on January 21st of 2020.
Okay. And so what was the offer state?
The offer is 4 years deferred and a $2,000 fine.
Okay. And Mr. Lacy, where's your client Thompson on this offer?
So I actually talked to the DA, and she actually agreed to 3 years deferred. We conveyed the offer to Ms. Thompson, Your Honor, and she has no problem accepting the offer. The issue is she wants to know how she can get the property, and she's claiming some of the property that was stolen actually belongs to her.
So who's the prosecutor you talked to?
It was
assigned to Amber Moore.
Yeah, but before that, I believe it was Kristen Jackson.
Mm-hmm.
And Ms. Burse, you don't see any notations about the different offer that counsel just stated?
I do not, Your Honor. The last notes I see are, hey, we need to resolve this case. Hey, I reached out to this person to resolve it. So,
okay. Ms. Burse, if you can reach out to Ms. Jackson, ask her if she made that offer to counsel. And then counsel, I'm going to set you all for a status on February 1st so you all can give some answers. Your client will need to log on to Zoom that day. So Mr. Lacy, you'll need to provide your client with the Zoom link that day.
Okay.
Okay. All right. Now, third call on Bonkowski.
Mr. Lacy, if you will do the pass slip and just sign by permission for the state.
Okay, we'll do.
Thank you.
All right. Lisa, let's go on the record. This is cause number F247084, South the State of Texas versus Anthony Bonkowski. Sir, is that your true and correct name?
Yes.
Can you read and understand the English language? Sir, can you read and understand the English language?
Yes.
And appearances from counsel?
Annalise DeFrank for the state.
Tim Lacy for defense.
And pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference is streaming on a public Facebook Live. All right. And, or excuse me, not Facebook, I'm sorry. We are on the court's YouTube account that was set up by the Office of the Court of Administration today. All right. Now, you all are here today for a bond sufficiency hearing. Defense, please call your first witness.
Yes, Your Honor. Correct. I would like to call Mr. Bonkowski.
Sir, as best as you can, please raise your right hand. Do you solemnly swear or affirm that the testimony you'll provide in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, defense, you may proceed.
Mr. Gronkowski, do you understand why you are here?
Partially. I believe that I had a court date that maybe my lawyer did not show up to, or there was a misunderstanding. So a warrant was issued for my arrest. However, I've already bonded out well over a year ago, and I'm following my conditions of bond. And I'm a functioning member of society and making good choices. This is just a misunderstanding, I believe.
And if the judge grants a bond today, where will you be staying?
With my mother in Dallas, Texas, permanently. I have severe Crohn's disease. I've been hospitalized 8 times in the past year. I get monthly infusions. So I, definitely plan to follow all of my conditions of bond and not get into any trouble. I'm not here with any new charges. I was just a normal traffic stop and had a warrant due to a technical difficulty, I believe.
And okay, thank you for covering your nose. Defense, you may proceed.
And you said you have a severe health issue. That's why it's important that you get out of here.
Yes, and if like probation is an option, I'm totally willing to go by those terms. But yes, I have a very serious health condition. I had my colon removed and my rectum removed, and I'm hospitalized pretty often due to my Crohn's disease flare-ups. I use the bathroom maybe 12 times a day.
And if the judge sets a bond, you intend to follow all your bond conditions?
Absolutely. Yes.
I'll pass the witness, Your Honor.
State.
Sir, do you have a Snapchat account?
No.
Never had a Snapchat account?
It's been a long time that I've deleted my Snapchat account.
Okay. Do you know why the victim would be getting Snapchat messages claiming to be you?
No, ma'am. I've had no contact with the victim since the day of my arrest. No contact whatsoever at all. I've not made a single attempt to contact the victim. I followed the order 100%. And maybe some impersonating, that is not me, ma'am.
Okay. So you're saying other people are creating different Snapchats and claiming to be you?
It's possible. But I mean, that must be the case because I have not made any contact with the victim since the arrest.
Okay. Does your Instagram bio say something about 91 days?
No.
And 91 days is the length of your, was the length of your emergency protective order, is that right?
Yes.
Okay. How long have you been in jail?
I was arrested, I believe, not this past Monday, but the Monday before that.
Okay.
And I'm definitely, scared straight. I'm not, I'm gonna follow every single term possible. I'm like bond or probation if possible. I will not get into any further trouble. Definitely learned my lesson, if that makes sense. But, I have not had any contact with the victim. I've not even attempted or looked them up or anything since the arrest. I'm taking this very seriously.
Nothing further.
Defense. Mr. Gronkowski, have you even been on social media at all?
We can't hear you all. So
Not-
if you, I don't know if you can scoot up closer towards the device for me. Okay, you said, Mr. Gronkowski, have you, and then I didn't hear anything else.
Mr. Gronkowski, have you been on social media at all?
No, I'm not very active on social media. Not Snapchat at all.
And have you called to complain and witness?
No, I have not made any phone calls, contact, nothing to the victim or witness or anyone.
Pass the witness, Your Honor.
State.
Nothing else.
Okay. Mr. Gronkowski, you said that you'll be living with your mom. What does your mom's address? Don't give me the full thing. What are the 4 numbers of her address?
Just recently moved from 3820 to.
Okay. When did you move?
Just in the past 2 months. It's in the
Okay,
same-
so you moved, hold on. you moved, what is this, January? So you all moved what month?
It would have been November.
Okay. So in June of 2021, that was still your address?
June 2021, yes.
Okay. So then, and that's the address that you used on your bond paperwork as well, correct?
The 3820 is what I used in my bond paperwork.
Right. And it was Spring Valley Road,
Spring
number
Valley.
414?
Yes, ma'am.
Okay. So let me pull up what the court's looking at. So you received a notice of court date back in June of 2021 with the same address that you listed on the bond paperwork. And the mail was returned to the court as if you didn't live there, but you did.
Okay, there may be an issue, but I can definitely update my information with the USPS to make sure I get all further mail.
Attempted, not known, unable to forward. So that's why this court held your bond insufficient, because you were given notice to come to court, and that notice was sent to you in June of 2021. And then your bond company actually filed an ATGOB based on that.
Mm-hmm.
But the warrant was already active from the court. So, Mr. Bunkowski, when was the last time you had been in contact with your attorney?
Just recently, actually. The last time I was in contact with the office would have been maybe just less than a week prior to my arrest.
Mm-hmm. And so let me see. Give me 1 second, sir.
I'm sorry.
Yeah, and the letter was also emailed to your bond company. So you're saying that AAA Atlas Bail Bonds didn't notify you of your court date?
They did call me about a court date, but I was under the impression I did not have to show up, that my lawyer was supposed to show up for me. But I do stay in contact with AAA Bail Bonds. I check in via online app every Monday, and I do call them occasionally just to make sure they got my update as well.
Okay, because they had noticed too. So, all right, that you were supposed to be here on July 6th of 2021. All right, counsel, any additional witnesses?
No additional witnesses, Your Honor.
You rest?
I do rest.
State?
State rest.
Defense, you close?
Your Honor, we're asking.
Hold on, do you close evidence, counsel?
Yes, Your Honor.
State, you close?
Yes, Judge.
All right, argument defense?
Your Honor, we're asking for a $1,500 bond, cash or surety. Mr. Bunkowski is going to stay in condition with all of his bond conditions. He has no contact with the complaining witness at all. And also, Your Honor, his health is very, very bad, Your Honor. He's on multiple medications. So him just being in here, especially with COVID, you know, it's not good. So we're asking that you set a bond of $1,500, Your Honor. As far as the misunderstanding, just for the record, Your Honor, we did send a pass slip. So I know there was a misunderstanding, but I just wanted to put that on record. We did send a pass slip.
Okay.
We are
You understand that the letter that was sent to him said that his appearance was required, right? And that was the letter that was emailed to the bond company counsel.
I understand what you're saying, Your Honor.
Sorry, I didn't hear you.
Yes, Your Honor, I do understand.
Okay, just making sure. All right, and state?
I mean, it's not clear whether or not he's having contact with the victim. We defer to the court on an amount of bond with that in mind.
Okay. The magistrate reviewed this case and set the bond at $75,000. I'm going to set the bond back at $75,000 as set by the magistrate. So you can either post a cash or surety bond, it's up to you. Your bond conditions will include no alcohol, no illicit substances, UAs at the court's direction, appear at all scheduled court settings, no contact with the complaining witness that's in the virtual world or the real world, and no contact with her family members. You are to stay away from her residence, place of employment, or any place that her or her family may frequent. No deadly weapons. And then state, has an offer been conveyed in this case?
An offer has not been conveyed yet.
Okay, so this case was indicted in June of 2021, June 1st to be exact, and state you all have not conveyed an offer.
We have not. I believe the case was inactive while the warrant was out. But I am working on it. I should have an offer by the end of the day.
Yeah, the case was pending for 4 months before the warrant was activated. So state you all have to convey offers to people. When's the discovery made available?
July 7th, 2021.
All right, I'm gonna set you off February 1st for a status. Please make sure you all talk about the case before you all appear in court. And make sure there's an offer conveyed state before that date.
Okay.
And then you all get a paper pass slip in. Sheriff Holden, Arce is gonna bring in those bond conditions. And then you all are excused. Let's go off the record.
You can sign for me. Thank you, Judge.
Thank you.
Can I talk to him?
Yeah, you got to put them on the other side. So Jordan can go back in the cell.
All right, Mr. Pass, we're on the third call on your case, Blanchard. You are here for a final announcement on 19 settings on the case. And where are you all at? And you're muted, Mr. Pass.
I have been trying to get in touch with the prosecutor, Annalise DeFrank, to negotiate with her. But she has made an offer. At this time, we're declining her offer.
Okay.
But I'm still hoping to negotiate it.
Okay, I'm gonna give you all today was your final one. So you all have had 19 settings. So I can't give you another announcement. I'll give you a trial date. And then if you all work it out, that is great. And if you don't, I understand.
Go ahead, Jordan. Go ahead, Jordan. Okay.
Judge, my client's out in the hall, I believe.
They called for him and I think he did sign in. So. Oh, sorry. Do we have Blanchard frame?
Judge, he's out in the hallway.
Okay, we can let him in. His attorney's on Zoom. Say, do you have your indictment ready?
Yes.
Okay. Okay. So excuse me, Lisa, let's go on the record. This is clause F19-25681, sell the state of Texas versus Charles Blanchard. Sir, is that your true and correct name?
Yes, ma'am.
And can you read and understand the English language?
I can.
And appearances from counsel?
Annalise DeFrank for the state.
Neil Pass for the defense.
And pursuant to the 45th emergency order issued by the Texas Supreme Court, we're operating virtually via Zoom. The Zoom video conference is streaming on the Texas Office of Court Administration YouTube account that they have created for this court. And you all are set today for a final announcement with 19 settings. And it's my understanding you all still have not come to a resolution. So the court is going to set you for trial. State, please make a record of the offense and the range of punishment and what rec was conveyed.
The offense is an assault, family violence, impede breath. It's a 3rd-degree felony. With a punishment range of 2 to 10 years. And the offer was conveyed on December 5th of 2019 of 3 deferred.
And counsel, your client's position on the state's offer.
We were trying to negotiate it down to a misdemeanor. I don't think any conversation with Mr. Frank over it. I have tried to contact her, but if that's her final offer, it's your final offer. I'm not there with my client today to consult with him, but so I don't know exactly what he wants to do.
It's okay. You all have had 19 settings. It sounds like you either have had the discussions, you haven't, but you definitely had enough time to have them. So I'm going to go ahead and set you all for trial. If you all are able to work it out before, that's great. So your trial date is April 5th. So on the pass slip in the blank provided, check off jury trial in April 5th. Your pretrial will be March 11th. All motions must be filed at least 7 days prior to the pretrial hearing pursuant to Article 28.01 of the Texas Code of Criminal Procedure. And then your trial announcement will be March 30th. All right, all 3 dates need to be placed on the pass slip. And then counsel, if you have a suppression issue, your motion must be substantive and the officer subject to the motion must be present at the pretrial hearing date. You all, please get that paper pass slip in. I know, Mr. Pass, you are virtual today. So state and defense, you all will need to work out how you're going to get that paper pass slip in. You all are excused. Mr. Blanchard, stay in contact with your attorney. You have to be present at all 3 of those dates. Okay. All right. You all are excused.
Can I speak to Mr. Frank? I'm just about to go back into trial.
Hey, you all have to work it out. You all knew you had this setting. So, and you knew it was a final setting. So
okay, I was just trying to find out if she was going to do the pass slip.
Can I sign for you?
Yes, please.
Okay, perfect. Let's go off the record. Thank you. Ms. Martin, go ahead and take a seat back at the table.
Yeah.
And then that's Walker that we need.
I'll call for Roger. You got to call last week. Oh, okay. All right. If they the room again.
All right, Lisa, let's go back on the record in the Walker matter. Mr. Walker, if you can scoot up closer towards the device for me. Okay. And Ms. Burris, you've now had an opportunity to read the ATRS. And do you have any questions for the defendant?
No, Your Honor.
Okay. So in looking at it, Mr. Walker, one of the questions your attorney asked you on direct examination was whether you were tired of getting in trouble. You recall that question?
Yes, ma'am.
Okay. And so I'm assuming the reason why counsel asked you that is because your criminal history dates back to 1997, correct?
Yes, ma'am.
Okay. And so from 1997 to present day, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 2. So you had over 20 arrests and you have had 2 probations that have been revoked, and you have had 2 TDC stints, and then you've done looks like county time and county time, and then just the 2 TDC for the, well, 5 TDC literally, but 2 of those cases, Berg have an ag robbery. And so, you know, in the 2 times that you were on probation in 1998 and in 2002, did you address your drug addiction issue?
No, ma'am. In 2002, I don't remember no probation.
Yes, August 20th of 2002, you were placed on deferred for criminal mischief and you were revoked and you did 100 days. And counsel's showing you the paperwork now, it looks like. So my question to you is, you know, I understand that the state doesn't have any questions, but I don't want to just put you on probation for more of the same, because counsel made a good point about, are you finally tired? And so I'm trying to figure out, what are you going to do differently this time? Because you talked about, oh, you have it under control now, but how so? Like, what efforts have you taken to learn how to manage your addiction? I didn't hear any testimony about that.
Not being around the same people and not going around bad people, staying out the way, and work every day, much as I can. And now that I got a grandbaby, so I have, something to do at home and stuff, even though I did have something to do. My mother just passed, so I really don't. And the outpatient treatment would help a lot. Me going to classes.
Okay. So, Mr. Walker.
Yes, ma'am.
I'd be failing you if I didn't ask this question. You blamed everybody else, but who's been with you since 1997 when you began in trouble?
Myself.
Exactly. Right. So you can't blame other people. You said you changed. You're not around those same people, but they weren't with you every time you were getting in trouble.
No, ma'am.
Okay. All right. Defense, please call your next witness.
That's all, Your Honor.
All right. You rest.
Rest, Your Honor.
And state you close.
Yes, Your Honor.
And defense you close.
Yes, Your Honor.
All right. Sir, pull up your stuff again. I do accept your pleas of guilty. I find that there is sufficient evidence to prove your guilt beyond a reasonable doubt in both cases. Pursuant to Article 42A.301, subsection A of the code, we have a risk assessment. You were listed as a high risk. Now, Mr. Walker, the Texas legislature requires a TRIS in every case because they want your probation terms to be specific to you and your needs, right? And so what the high means is that they're thinking you need a lot of help on probation, or that you're going to struggle on the probation, okay? And so I will grant the party's request and accept the plea agreement, so I'll defer adjudication of your guilt. And it was 3 deferred in both cases, correct?
Yes, Your Honor.
Okay. And I will place you on community supervision for a period of 3 years. There are two things you need to understand about being placed on deferred. You do have the right to petition the court for an order of non-disclosure. The only reason you would not be eligible is because of the offense you pled to today and any prior criminal history you might have. Second thing, the full range of punishment that the court reviewed with you at the beginning of the plea is available to the court should you violate your terms of probation. Do you understand both of those things?
Yes, ma'am.
Okay, I am going to order that you do the inpatient treatment. Now, Mr. Walker, it is an open college campus, so you can walk off if you want to. So I'm hesitant to send you to Wilmer because I don't want to waste the money for a grant for you when I could send somebody else and use that money, or just send you to SafeP. So, you know, the way this works, Mr. Walker, and I always like people to be armed with information, is that if you leave that facility without the court's permission, then there will be a warrant issued for your arrest. And your Texas legislature has said that you won't get any of that back time if you leave that program without successfully completing it. So let's say, for example, you're there for, I don't know, 3 months, well, 2 months, and you leave, you won't get that back time. Okay, do you understand that?
Yeah.
Okay. Can you cover your nose for me? Okay. All right. So you'll go to Wilmer. You'll do whatever aftercare continuum that they deem is necessary. Mr. Atkins, I want him to check in a week after he's released to make sure that everything's going okay. I am going to order IOP. I'm sorry. Looking at your chart, it looks like I'll do NA. NA 2 times a week. And then based on your TRES for Mr. Atkins, he needs to check in with his field officer and the court officers once a month. Mr. Walker, I'm doing that because I don't want you to fail. You have had an extensive criminal history. It's time to stop the back and forth, the revolving door. So we're going to try to do things differently than what you've done them before. Do you understand that?
Yes, well, understand. So
Sorry, hold
IOP
on.
is that
What?
close.
Hold on.
Okay.
I told you no IOP. I'm going to do NA instead 2 times a week. But what you need to appreciate, Mr. Walker, is that you can no longer be a bystander in your rehabilitation. There are 2 purposes for the adult criminal justice system, either punishment or rehabilitation. If you want to do the rehabilitation, then you have to get on the field and do the work. So you blaming other people, I'm going to really have to teach you accountability. This is about you doing different for you. You can't do different for your grandchild until you change you. Do you understand that?
Yes, ma'am.
Okay. So I'm not looking for perfection, Mr. Walker, but what I am looking for is no excuses. Things won't always be perfect, but you can do better than what you've been doing. You understand that?
Yes, ma'am.
Okay. So when he comes in that first week after Wilmer, Mr. Atkins, please give him that employment list. One of your conditions of probation is to be employed. And I try to help you with that by providing a list of employers that hire people with felony backgrounds. Mr. Atkins, make sure that that list has www.cornbreadhustle.com at the bottom. It's another resource. They always list jobs and all kinds of trainings for people who typically have challenges finding employment. Now, what else? I think that to start. Can you think of anything else, Mr. Walker, that you might need to succeed on this probation?
Nope.
Okay.
No, ma'am.
Okay.
Can I ask you a question?
Are you sure you want to?
Yes, ma'am.
Okay.
How long do it take William to come get you?
That is a question that probation may be able to answer and might not. Mr. Atkins, can you answer that?
Judge, I'll look into that and I'll talk with Mr. Walker.
Okay, perfect. All right. And then, counsel, are you appointed or retained?
Appointed, Your Honor.
All right. So, sir, has your financial status changed since you were appointed counsel? Has it gotten better? Has it gotten worse?
Financially, are you better than when I got appointed, or is it the same?
Oh, better.
How so?
I mean, no more trouble, nothing.
Oh,
no,
so
financially, your wallet, your pockets. Are you better off or worse off or the same? Do you have more money, sir, than you did before?
No, it's the same. I mean.
Okay, thank you. So pursuant to Article 4215 of the code, I'm going to waive your court costs in both cases.
Thank you.
And then you're welcome. And then I'll review with you the trial court certification of defendant's right of appeal. It reads the same at the top. It acknowledges that these are criminal cases, and there's a box checked off on each of them above the court signature that state that you waive your right to an appeal because you entered into a plea agreement. Do you understand that?
Yes, ma'am.
Okay, perfect. So sheriff's officers, let's make sure we've printed him twice. Let's hold him for probation. And then attorneys, you all are excused. Let's go off the record.
Thank you, Your Honor.
You're welcome.
Probation will be able to shut in. Okay, and I'll let your attorney know that we got it done, okay? Okay. Yes.
I'm down to wait for Will.
Yes. And probation's gonna talk to you about how long that's gonna take. Thank you.
All right, take care.
All right, Mr. Schottmeyer, these are third calls on all your cases. So you had David Gonzalez for a status. He was in quarantine last time. You're muted.
Just going to talk to her. Judge, I'm going to sign off here and just be at the table, Your Honor. Oh, good afternoon, Your Honor.
Good afternoon, Mr. Schottmeyer.
David Gonzalez, the state wishes to take a deposition of the complaining witness, Miss.
Oh, this is Miss. Yeah, you weren't on last time. This is Miss
Marissa
Hatchett's case.
Hatchett.
Yeah. Okay. So I believe she was going to be sending the court an email. Let me check.
Yes, Your
Because
Honor.
we've been having email problems. And who else did you have? You had.
I had Mr. Dickerson. Here is Dickerson. Just want to add.
Dickerson. Okay, you have Urian Dickerson. All right. And you all were set for a plea today.
Yeah, well, Judge, we actually, yes, and we've, we're being broadcast, are we not, Your Honor?
We are. Do you see the live on YouTube at the top?
Yeah, I think we've reached an accord with the state and the probation department. They wish to have 15 days in jail.
State, can you share the motion, and are they identical in both cases?
Judge, I apologize. I didn't know that he was on this case. So if you can bear with me for a minute while I bring that up.
Hillary Wright is kind of the point person who's not in this court, if that refreshes your memory, and Geneva Rachel. There were some, he was beneficial for the state.
Judge, I have them now, and it appears that they are identical. Would you like me to?
Okay, you can share one.
The court able to see it?
Yes.
You want me to make
Okay,
it?
so May 3rd of 2021. All right, I'm ready for the file date, September 2021, and served January 4th. All right, and the allegations. All right. No trespass, fail to ID. Not reporting. Okay, so you all, I understand you all have an agreement let me explain to you that to make sure that we don't have a revolving door with Dickerson, I talk through the allegations. If that's not something that you all are willing to do or you want to do, then you all will have to reconsider your proposed agreement. Do you all have any questions about that?
No, Your Honor.
Okay. So the non-reporting, just so that we don't have the same issue again and another motion gets filed, why wasn't your client reporting?
Judge, during the COVID, I think what happened is he missed a report or two and he became scared. And at that point, he kind of fell out of the system, Your Honor. And I've gotten to work with him closely over the last couple of weeks, pretty intimately. And I know this guy's got a good heart. I know he wants to be successful on probation. He's shown me that he's things I really can't articulate right now, but I think as Ms. Phillips would demonstrate through the notes that he's more than willing to step up and take care of his civic duty in any regard, Your Honor.
So is it also that he picked up those new charges?
Well,
Because they're right after.
Yeah, that's exactly right, Your Honor. Yes.
Okay. State, what's going on with the 2 misdemeanors?
I believe they're still pending because we have our cases pending, but let me double check.
They are, Your Honor.
And what was your proposed agreement?
15 days in jail, Judge.
And then for him to be continued.
I can do 30. I
We'll
can't
take-
do any less than that.
Well, 30 is fair, Judge.
All right. Now, sir, you can't be on probation picking up new allegations and not reporting. And then, I don't want to send the message to you that, that's okay, because it's not. You have to report. That's like the bare minimum. All you had to do during the pandemic was pick up the phone.
Yes, ma'am. Yes, Your Honor.
Okay. All right. So, Ms. McCabe, do 30 days on the cause ending in 308. And please make sure you put the date of release as opposed to the actual number of days. Okay. All right. And then he's good to go. Sheriff Hold'em for probation.
Yes,
All right. Okay, you all.